Greetings to all. Welcome back to our YouTube channel. Myself Sanchita Sanand, a first year law student from Galgotias University and currently working as a legal intern at LEXIS and Company. So today I am here to talk about the direct tax Vivad se Vishwas bill of 2020. The Honorable Finance Minister Nirmala Sitharaman on 1st of February 2020 in her speech for Budget 2020 announced the Direct Tax Vivad se Vishwas scheme. The reason for introduction of the scheme is to reduce the pending income tax litigations at various appellate forums and timely collection of the revenue. The bill was approved by the lower house of the parliament on 4th of March 2020, and on the same day the Central Board of Direct Taxes issued clarification White Circular number 7/2020 in the form of FAQs. Subsequently, the bill became an act upon getting assent of the President on 17th March 2020. The relevant rules were prescribed on 18th of March 2020. Further, the CBDT issued circular number 9/2020 while dated 22 April 2020 with certain modification in the earlier circular. For easy understanding, the scheme can be summarized in simple language as under. Appellant. The bill defines an appellant as the income tax authority or the person or both whose appeal is pending before any appellate forum as on 31st of January 2020. These appellate forums are the Supreme Court, the High Courts, the Income Tax Appellate Tribunals and the Commissioner. Resolution mechanism. The bill proposes a resolution mechanism under which an appellant can file a declaration to the designated authority to initiate resolution of pending direct tax disputes. Resolution mechanism. The bill proposes a resolution mechanism under which an appellant can file a declaration to the designated authority to initiate resolution of pending direct tax disputes. The last date to file such declaration will be notified by the central government. Based on the declaration, the designated authority will determine the amount payable by the appellant against the dispute and grant a certificate containing particulars of the amount payable within 15 days of the receipt of the declaration. The appellant must pay this amount within 15 days of the receipt of the certificate and inform the designated authority of such payment. Such amount will not be refundable. Once the designated authority issues the certificate, appeals pending before the income tax appellate tribunals and the commissioner will be deemed to be withdrawn. In case of appeals or petitions pending before the Supreme Court and High Courts, the appellant is required to withdraw the appeal or petition. The Principal Chief Commissioner will designate an officer not below the rank of a Commissioner of Income Tax as the designated authority to manage the proposed resolution mechanism. Amount payable for resolution. The amount payable by the appellant for resolution of disputes is determined based on whether the dispute relates to payment of tax or payment of interest, penalty or fee. Further, he is required to pay an additional amount if such payment is made after March 31st, 2020. Table 1 shows the amount payable by the appellant for dispute resolution. Waiver of rights. For dispute resolution, the appellant is required to furnish an undertaking waiving his rights to seek any remedy or claim in relation to that dispute under any law including the Income Tax Act 1961. All such claims already filed in relation to the dispute must be withdrawn before filing the declaration. Immunity to appellant. Once a dispute is resolved, the designated authority cannot levy interest or penalty in relation to that dispute. Further, no appellate forum can make a decision in relation to the matter of dispute once it is resolved. Such matters cannot be reopened in any proceeding under any law including the IT Act. Revival of disputes. The declaration filed by an appellant will become invalid if first, its particulars are found to be false, second, he violates any of the conditions referred to in the IT Act, or third, he seeks any remedy or claim in relation to that dispute. Consequently, all proceedings and claims withdrawn based on the declaration will be deemed to have been revived. Disputes not covered. The proposed mechanism will not cover certain disputes. These include disputes, first of all, where prosecution has been initiated before the declaration is filed. Second, which involves persons who have been convicted or are being prosecuted for offences under certain laws such as the Indian Penal Code or for enforcement of civil liabilities. And third, involving undisclosed foreign income or assets. Significance of the scheme. It should be noted that the response to the scheme gains significance given earlier schemes like Kar Vivad Samadhan Scheme 1998 and Direct Tax Dispute Resolution Scheme of 2016 did not yield much results. This scheme has reportedly received an overwhelming response with a settlement amount of over rupees 97,000 crore as of February. So far, over 1,25,000 of the 5,10,000 long pending cases have been settled under the scheme. These comprise 24.5% of the total number of such cases which were pending before the scheme was introduced. So this was all about the Direct Tax Vivad Se Vishwas Bill of 2020. Thank you so much for devoting your time and listening to my video. If you really liked it, then please like, share and comment. And do subscribe to our YouTube channel Lexcliq for more upcoming such videos. Thank you so much and have a nice day.